Greetings and welcome to Tort, Wrongful Acts and Breach of Duty, Part 2. Let's get right down to where we left off, but before we start, just to remind everyone, this broadcast is strictly for the entertainment and educational purposes of the YouTube channel, not to be used, misconstrued, or misused for anything legal, lawful, professional, private, business, tax, financial, or otherwise. So please don't do this at home. Let's proceed. All right, we left off last time, just to give a quick refresher, we were mentioning the differences and distinctions between contractual relationships and when there's a contractual breach becomes a tort. Since they are separate, the tort and contract may coexist where independent duty exists. And what we're getting here was that every agreement carries an implied covenant of good faith and fair dealing. From that, we see where the tort comes from, regardless of the contract. So they could be independent of an action with a breach of contract. But again, the courts will ask whether the duty stems from law or solely from the contract to see if there's a tort action. And foreseeable third parties may require absent privity when legal duty extends to them. Again, non-performance alone is not tortious without additional wrongdoing. The key point here is that non-performance alone. All right, and practice tip we had regarding the duties arising in contracts that practitioners should identify whether obligations arise from the agreement or general law. Remember that duty, fair dealing, or general law to determine if tort remedies apply. Plead tort and contract counts separately, explaining the independent duty. Avoid duplicative damages claims for the same loss and highlight the bad faith or public policy violations to sustain tort theory, not just a contractual breach. All right, and we went through that summary from last time. The intentional, malicious, and reckless acts share a common foundation: conscious disregard of others' rights and safety. So the intent distinguishes deliberate harm from negligence. The intent from just negligence. Negligence doesn't always require that intent. The malice aggravates liability, but rarely creates a tort alone. So it aggravates the liability, but the malice rarely creates the tort alone. Recklessness substitutes for intent when danger is known and ignored. So again, it's the knowledge and the intent. And on them, greetings to you. We are on like Tom. So the statutory breaches and bad faith acts often intertwine with these principles. So again, these independent yet concurrent. Courts weigh motive only when justification or privilege is asserted. Key point. Okay, now we're on to tonight's presentation, the intentional interference with contractual relations. Intentionally disrupting another's valid contract or business expectancy without privilege, meaning they're not part of this transaction, creates liability for interference. Elements are: 1, a valid contract or expectancy; 2, knowledge by the defendant of that valid contract; and 3, intentional interference; and of course, with every tort, 4, damage. Malice or improper motive strengthens the liability. Incidental interference does not. Interference may include business expectancies, even absent written contract. Again, these interferences in fair dealing and things like that, if they interfere with that, it could be absent the written contract. Competition is privileged if pursued in good faith and without unlawful means. So there's privilege from any kind of tort action here if it's just mere competition. And we have some of the cases here. Erickson's Flooring versus Tembeck from the Sixth Circuit in 2007. No tortious interference without breach or resulting damage. See, it's not requiring for the breach. That resulting damage is key for the tort. LaSalle Bank versus Morin Foods, Northern District of Illinois, 2007. Elements for interference with prospective advantage are defined. So this LaSalle Bank is a very important case. If you're in Illinois, and it's referred to quite a bit, I've seen. The Mintz versus Blue Cross of California, in 2009, 5-part test for interference with contractual relations. So these are good, if not precedents, are good persuasive cases to refer to involving intentional interference with contractual relations, otherwise known as interlopers. Let's continue. And we have Section 21, the torts arising alongside contract claims. The contract breach plus violation of independent legal duty supports tort action. Bad faith, fraud, or coercion within a contract may not sound in tort, protected by that contract. Insurance and fiduciary contracts often give rise to overlapping remedies. So if there's fiduciary duties in the contract and there's the implied covenant of good faith and fair dealing, then indeed you may have overlapping remedies. Economic loss rules may limit recovery absent independent duty. Yeah. And then there's Speed versus Scott in Mississippi in 2001. The outrage requires willful and wanton conduct. And Dahlberg versus Lutheran Social Services, the employer or conduct not sufficiently outrageous. Of course, the IIED is the intentional infliction of emotional distress. That's a tort for on the person. Bongum versus Action Toyota Incorporated in the Fourth Circuit, 2001. The elements of an intentional infliction of emotional distress, IIED claim under Maryland law are 1. So this is a good test here for anywhere. Remember, this is in Maryland. However, let's look at this test. 1, the conduct must be intentional or reckless. 2, the conduct must be extreme and outrageous. 3, there must be a causal connection between the wrongful act and the emotional distress. And 4, the emotional distress must be severe. So reckless, meaning that you're aware of what it could occur and you're consciously doing it. Now we're on to the effects of statutes. Oh gosh, that was on there that whole time. Sorry about that, guys. All right, is it true torts take action against the corporation and not the individual? I wouldn't be so certain of that. However, remember that the torts purpose is to provide remedy for the person, the individual that's caused damage, or the private damages that have occurred because of a breach of law or duty. So we're on to the effects of statutes. Modern statutes unify procedure, but retain substantive distinctions between contract and tort rights and remedies. So the statutes may expand or restrict tort recovery for contractual breaches. This is with contracts. Merged procedural rules do not erase substantive differences. So merged procedural rules do not erase any kind of substantive differences, even if they're merged. Classification affects limitation periods, defenses, and damages. These are, of course, statutory. Courts examine legislative intent to determine civil liability. Kind of strange here that courts examine legislative intent. That should be pretty clear in the statutes as it stands to determine civil liability. But as we've learned, that tort is ever evolving practice, so things can change and change with conditions socially and otherwise. So I can kind of see why the intent comes into play a lot more so with tort actions than actions in law or equity. Okay, we're on to Section 23, causation and privity. Liability turns on a causal link between wrongful conduct and injury. Privity is no longer a prerequisite when foreseeability exists. Privity is abandoned in modern torts if harm is a foreseeable result. So again, we get to the foreseeable result. That's that recklessness when you know it's something that could cause a problem, yet it's done anyways. And you know so the relationship in the modern torts, the between the parties, the privity is abandoned if there's a foreseeable result in the harm. The causation requires a proof of actual and approximate connection. The defendant is liable for natural and probable consequences of the act. So the natural and probable, that's with torts. Unforeseeable independent causes usually break the causal chain. So if it's unforeseeable, it takes away that intent part. It's more towards negligence now than tort. So if it's unforeseeable, the independent causes usually break the causal chain. Because if they're foreseeable, you don't have that chain of the foreseeable result and the intent, the proof of the actual and proximate connections. So we see how we're splitting hairs here between liability in a tort and in negligence, which would be something where it just happened, but because of the nature of what act it was in or what conditions it was in, there has to be a remedy. Of course, that wouldn't fall under the tort. So we're focusing on tort. Let's see if this goes next page. There we go. Intentional injuries and proximate cause. Intentional wrongdoers are responsible for a broader scope of harm than negligent actors. So, again, the intentional wrongdoers in tort is a broader scope of harm than mere negligence. Intentional acts extend liability to all foreseeable and intended results. So not just their intended, but even foreseeable ones. Courts consider culpability, so the responsibility, the seriousness, and the deviation from due care. And greater moral blame justifies wider liability boundaries. So the more moral blame, the wider the liability. And here's a restatement, the third of torts, section 33. Intentional or reckless harm entails broader consequences than negligence. So it'd be interesting to read the restatement of torts. Section 25, the willful acts and intervening causes. Deliberate wrongdoing remains a proximate cause of injury, even when subsequent events contribute to the result. Intentional acts create liability, despite unforeseen outcomes. Intervening negligence rarely relieves a willful tortfeasor. So the intervening negligence rarely relieves a willful tortfeasor. Intent toward one person extends to injuries inflicted on another. So those third parties, someone's not even privy to the whole transaction. If they're injured, that intent can even extend to them because of the foreseeable consequences. Courts emphasize deterrence and moral accountability. Now we're on to unlawful acts. Those committing unlawful or illegal acts bear liability for resulting harm, even when the specific injury was unintended, because ignorance of the law is no excuse. Violation of criminal or regulatory law may form tort basis. Causal connection to injury is required. Remember, we need that cause to the injury connection for the tort to be valid. Civil recovery complements, not duplicates, criminal sanction. The research reference here is the Pharmacist Malpractice Trial and Litigation Strategies, 78 Am Jur. Okay. We'll look at that next time. Let's proceed. Protected interest generally. Tort law safeguards both tangible and intangible interests, life, reputation, property, and emotional tranquility. Recovery requires invasion of a legally recognized interest. Legally recognized interest. Law adapts to social values in defining protected interests, and the protection extends to personal dignity and fair opportunity. So think about that. Fair opportunity. Opportunity to access. Staub versus Proctor Hospital, 2011. Intentional torts require intent to cause consequences. So the intent to cause the consequences. Again, that causal connection. Then there's Maya versus City of New York. Ethnic slurs by police officers may constitute intentional infliction of emotional distress. And then there's Mace versus Ford Motor Company in West Virginia, 2007. Spoliation, remember that's not spoil, that's spoliation, the taking away of something unlawfully, is tortious when a duty to preserve evidence exists. Oh boy. A duty to preserve evidence exists, and the spoliation is tortious. Interesting one there. Let's proceed. Ooh, now we're on to damage to reputation. Reputation, though intangible, is a legally protected interest comparable to life, liberty, and property. Defamation protects individuals from false statements causing harm. Words must be false, published, and injurious to reputation. Truth and privilege are complete defenses. So privilege to damaging a reputation. Damage is measured by loss to standing or livelihood. So the damages are measured by the loss to standing or livelihood. I don't know why we get this the pharmacist malpractice reference here again. Anyways, this is from Am Jur. Again, these are the references, so let's continue. Rudeness, threats, and abusive language. Tort law distinguishes between mere discourtesy and verbal conduct causing actual measurable harm. Simple rudeness or insult is not actionable. Threats actionable when causing imminent fear or economic coercion. Defamation requires factual assertion, not opinion or hyperbole. Businesses may be liable for employee abuse of patrons. And baseless threats of litigation may support abuse of process claims. And now we get to outrage, the principles. Extreme outrageous conduct that shocks the conscience creates liability for severe emotional distress. Extreme outrageous conduct that shocks the conscience requires intentional or reckless conduct that is extreme and outrageous. The conduct must exceed all possible bounds of decency. All possible bounds of decency. Minor indignities or cold behavior are not actionable. The typical examples: egregious harassment, deceit, or abuse of authority. So these are some of the outrage principles. Here's your abuse of authority. Come on. All right, now we're on to case applications of outrage. Cases demonstrating the application of outrage principles in various contexts. So we have Shaw versus Shell Oil Products in Connecticut, 2000. Employers' investigation of racist remark allegations are not extreme or outrageous. There is no proof of fabrication. So the employer's investigation of racist remark allegations were not extreme or outrageous. There was no proof of fabrication. There's Potts versus Hayes in Alabama, 2000. To recover, plaintiff must show 1. Intentional or reckless conduct, and 2. Extreme and outrageous character, and 3. Distress beyond endurance. And then we have Callens versus Jefferson County Nursing Home in Alabama, 2000. A lot of those torts in Alabama in 2000. Nursing home's restraint of resident, yikes, and concealment of injury was not sufficiently outrageous. Wow, I don't think I'd want to be in a nursing home in Alabama. Then there's Meininger versus Koniag Incorporated in Alaska, 2001. The intentional infliction of emotional distress liability rises only for conduct utterly intolerable in civilized community. Wow, that's an outrageous one there too. I think this one thing here kind of behooves us to take a look at one other. Give me one moment here. There was an aspect to some of these terms here, and it would probably be a good idea to refresh ourselves with some of these terms here to make sure that don't get confused, because we have terms like wanton and reckless, negligent, and I had a slide that had all these in them, and I'm trying to see which number it was, but it's definitely something to be aware of, that there are these distinctions between these terms and that they definitely are part of the actions. So we got negligence, willfulness, negligence. Okay, well, yep, I can't find it here. Oh, here we go. There we go. All right, let me jump it over here real quick. It's important to keep track of these things. So we have willful, wanton, and reckless. So willful, now these go down degrees of, the worst here, starting with willful, deliberate intent to cause harm. Then there's wanton, the conscious indifference to a known risk. So you know the foreseeable outcome. Reckless is disregard of substantial risk likely to result in serious harm, but it's not a conscious indifference. It's just a disregard. So the severity of that disregard determines whether the conduct exceeds negligence, and the punitive damages often hinge on willful or wanton proof. So willful and wanton, reckless starts to move towards negligence and outside of tort exclusively. So just want to throw those distinctions in there. We see reckless, that it's starting to go towards negligence either totally or partially, and willful and wanton are typically where you'd want to be for tort. All right, let's move along here. And is that all we had for the cases? Huh. Yeah, a second. Thought I had more cases than that. No, that's it. We have quite a few. We had some in the last one there too. Let's proceed. Oh no, here they are. So here's some additional cases demonstrating the application of outrage principles in various contexts. Palmer versus Arkansas Council on Economic Education, 2001. An employee's dispute with nonprofit directors and termination was not beyond all bounds of decency. Lively versus Flexible Packaging Association, DC, in 2001. President's remark calling employee dumbest girl I've ever seen with later termination was not outrageous. Perhaps there was some truth to the statement. Blockham versus Fieldale Farms Corporation, 2002. Extreme and outrageous conduct causing distress subjects actor to liability for distress and resulting bodily harm. So it's extreme and outrageous conduct. Whatever was happening there in that farm was extreme and outrageous, and it caused distress to the subject's actors for liability to distress and resulting bodily harm. So it must have been really bad. Then there's Shop versus Gucci America Incorporated, 2000. Fashion managers' insults about appearance and job performance were not actionable. So I guess a fashion manager didn't like someone's appearance. They tried to sue, and it seems it was not actionable. Then there's Osborne versus Payne in Kentucky 2000. Outrage remedy excludes petty insults and cold behavior. It addresses conduct truly intolerable. So here we go, more outrageous cases. Final cases demonstrating the application of outrage principles in various contexts. There's Heckman versus Detroit Chief of Police, 2005. Conduct must go beyond all possible bounds of decency to impose liability, of course. And Speed versus Scott, Mississippi, 2001. The fire chief's accusations calling a firefighter a liar and thief was not sufficiently outrageous. And then there's Dahlberg versus the Lutheran Social Services of North Dakota, 2001. The threshold for outrageousness is narrowly limited to extreme conduct. And then there's Klopfel versus Bokor in 2003. Outrage and intentional infliction of emotional distress are synonymous. So outrage and IIED are synonymous. Interesting. That'd be an interesting case to see how they came upon that. Then there's Rabideau versus City of Racine, 2001. Actor intentionally causing severe emotional distress is liable for that distress and resulting bodily harm. All right, hope you get enough cases there. Let's move along. And we're good on the chat. Section 31, interference with personal and family rights. Tort law safeguards domestic harmony and personal relationships from unwarranted interference or intrusion. Individuals enjoy rights to companionship, consortium, and family stability. Interference with marital or parental relations may be actionable where malice or wrongful means exist. Children's recovery for loss of parental society is limited to statutory provisions. Wow. Courts guard against expanding liability where policy favors family privacy. Yeah. All right, that's a contentious one there. Section 32, interference with property rights. Okay. Unlawful invasion of another's property, interest, or possession creates liability, even absent physical damage. A duty exists to respect others' possession and use of property. Interference may be intentional, negligent, or reckless. Property includes tangible things and certain intangible interests, like rights. Remedies encompass compensatory and sometimes punitive damages. These are your tort remedies. Compensatory and sometimes punitive in a tort. And then we're back to Mejia versus New York, City of New York, 2000. Excessive police conduct is actionable as intentional infliction of emotional distress. I think that's the slur they were using. Ethnic slur. Girl Scouts versus Girl Scouts of U.S. of America. And that's Wisconsin, 2010. Economic expectancy interference recognized in organizational name dispute. Oh, okay. They're trying to steal the name. So that was recognized. Then there's Mars and Smith Partnership versus D.K. Boyd Oil and Gas Company in Texas Appellate, 2005. Intentional interference with mineral lease and equipment use established liability. So there you go. You got the tort action there. And we're on to interference with right to services. Wrongfully depriving another of services owed by employee, spouse, or child constitutes an actionable tort. Injury to master, parent, or spouse, master, through loss of services is compensable. Employer may recover if third party injures employee, preventing performance. Wow. Liability attaches where services are intentionally diverted or obstructed. And public entities owe duties to furnish non-discriminatory services to all qualified users. Wonder if they know that. All right, now we're on to Section 34, the perversion or compulsion of legal remedies. The misuse of legal process, such as malicious prosecution, false imprisonment, or abuse of process, creates liability for the resulting harm. Abuse of process involves using legal procedures for an ulterior purpose. False imprisonment protects freedom from unlawful restraint. Recovery of cost in original action often bars further damages claim, though. Malicious prosecution requires malice, lack of probable cause, and termination in plaintiff's favor. Wow. And courts guard access to justice, but condemn weaponizing litigation. In Huggins versus Wright, Mississippi 2000, refusal to provide utilities, though distressing, did not meet the threshold for outrageous conduct. Wow. Mississippi. Section 35, the implied causes of action for state constitutional violations. Some jurisdictions recognize direct tort remedies for constitutional violations. Others confine enforcement to statutory or equitable relief. Federal law implies damages actions for constitutional breaches. And that's Bivens types claims. Okay, we've heard of these. These are federal damages for constitutional breaches. Bivens. State recognition varies. Some allow tort recovery for unlawful search or denial of rights. Separation of powers concerns limit expansion of implied remedies, and courts balance deterrence of official misconduct against legislative prerogative. So we have here Illis versus AutoZone Stores Incorporated, 2001. A verdict of $253,500 was upheld for physical injury and loss of services. Recognized tortious violation of duty under state law. That's a slip and fall when it happened there. All right, let's move along. Practice tip. Merging areas of tort accountability. Constitutional torts, privacy intrusions, and digital harms illustrate tort law's continuing evolution toward protecting personal dignity and data security. Now this is probably a good 10 years old, this AmJur that we're extracting this from. So think about the digital harms and how much this has been changing and emerging in areas of tort. Identify statutory frameworks before asserting implied torts. Plead constitutional provisions and causation distinctly from negligent counts, as we read earlier. Seek declaratory relief alongside damages where immunity may arise. Seek declaratory relief alongside damages where immunity may arise. Preserve evidence of governmental custom or policy for Monell-style liability analogs. And I'll go into quite detail the Monell claims and I think the Bivens as well in the Blame It on the Man live stream. It's over a year ago, maybe even longer than that, on the channel in the miscellaneous playlist. But that one we go into extreme detail and with some much more recent cases for that and how the courts have been ruling in those cases and some alternative strategies. Cumulative document summary. So let's go over what we went over tonight. The closing sections demonstrate tort law's breadth from family harmony to constitutional accountability, unified by the principle that every right implies a corresponding duty. Personal, property, and relational rights from the fabric of civil liberty. Wrongful interference demands both invasion of right and an absence of privilege. So they're not party to something else. We say the privilege It's an invasion. Abuse of legal process transforms justice into injury. Modern courts cautiously recognize new torts to preserve balance between liberty and responsibility. All right, we have just a few more to go through on this. Maybe we'll just continue if everyone's still here. Let me know in the chat. We get to the integrated review of intentional and strict liability themes. The intentional and strict liability torts impose accountability without reliance on negligence, ensuring deterrence of deliberate or abnormally dangerous conduct. Outrageous. Intentional torts center on volitional acts and knowledge of harms, on your own volition and intent. Strict liability addresses risk creation regardless of fault. Both doctrines prioritize protection of vulnerable interests. And the courts harmonize fairness and policy through proportional remedies. Nice. And here's our comparative doctrine. This is real critical here, understanding the continuum. And there is a continuum between negligence, recklessness, and intent. It aids in selecting the proper theory and the damages measure. So starting with negligence, failure to use due care. Recklessness, conscious disregard of risk. Intent, the purpose or substantial certainty of harm. Different mental states yield escalating liability and remedies. So the measure of the liability and the measure of the remedies is determined upon the different mental states: negligence, recklessness, intent. And that's that wanton and reckless. Okay, and on to the next slide. We're just about done with this section here. Damages and remedies overview. The remedies translate legal wrongs into compensatory, punitive, or equitable relief to restore balance and deter misconduct. Compensatory damages make plaintiff whole. So that's the purpose of the compensatory, to compensate by making the plaintiff whole. Nominal damages vindicate technical rights. So the nominal are the ones that are not as of a direct result, but resulting from the damage, the violations. The punitive damages punish and deter egregious wrongs. Equitable relief prevents continuing harm, and the courts calibrate awards by culpability and social policy. So how much responsibility and how much society will tolerate. Oh, and on to our practice tip, proving causation and injury. Causation is the linchpin of tort recovery. Remember, the causal link. Documentation and expert evidence bridge the gap between wrong and remedy. Establish both but-for and proximate causation, as we reviewed before, the but-for and the proximate. Use expert testimony for complex or latent injuries. Link each element of damage to specific wrongful acts. Each element of damage to a specific act. Anticipate intervening cause defenses with factual precision. And a policy reflection, tort law as social balance. Tort law mediates between individual freedom and collective security, reaffirming that rights imply responsibility, encourages care while preserving liberty of action. It compensates victims without crippling enterprise. It evolves through precedent to reflect moral progress, ideally, and serves as a constitutional safeguard for private justice. Remember, these are remedies for private injuries. Conclusion and continuity. From ancient trespass to modern privacy and constitutional claims, tort law remains the living instrument of accountability in civil society. Tort law adapts to protect emerging interests. Each generation redefines the boundaries of duty and fault. Justice depends on measured remedies and truthful causation. The continuing challenge? Align compensation, deterrence, and fairness. And that brings us to the end of part 2 of wrongful acts and breach of duty, torts. And we're going to continue on with part 3 next time, and if necessary, a part 4, but I believe we should be able to meet everything in there with part 3 and wrap it all up. But I hope you all have learned a little bit of something here about torts. I know I've definitely learned a lot more, and to find those distinctions between the negligence, the liability, the recklessness. Yes, and the most beautiful buzzkill. Thank you for attending, and good to see you are there reading a book in the icon, which is ideal. Yes, definitely. I'm glad everyone was able to get a little something out of this. And as I said, we will be continuing with part 3 shortly. And I believe part 3 will be taking us to our 100th live stream of American jurisprudence. So we'll try and make something special for that one. And definitely keep the notifications on to make sure you get noticed when that one occurs. I'd like to thank you all for coming here. And yes, torts are the quasi-law. We can say that because it's where law and equity doesn't provide a remedy. So this is a good way that we're able to keep a civil society, protect both the freedom to do things and keep everyone safe without causing undue restraints. With that said, please hit the like so we get the word out there, and I hope to see you all on the next one. Peace out.